PR application, once you have submitted, can be a very stressful and an anxious journey. Right from the time you click on the submit button, you get your AOR, until you get your COPR, permanent residence confirmation, or ECOPR, what you like to call. It is full of anxiety, full of questions, full of curiosity, full of frustrations, of course, and obviously at all times a lot of nervousness and stress. In a lot of cases, people expect that they would receive their AOR, they would receive their medicals, they would receive their biometrics. After that, in some cases, you receive what is referred to as an ADR, additional document request, where an officer is asking you for some additional documents in order to make the decision, in order to complete your application. They could vary from pay slips, pay stubs, some more updated proof of funds, updated police clearances, updated employment letters, most of these documents. And then there is that dreaded PFL, Procedural Fairness Letter. As the term itself is very indicative that this is as per the procedure to give you, to basically maintain the fairness in the system. This is a chance that the officer is giving you before they refuse your application. That is the chance that is being given. So obviously it's like a do or die situation in your application. You could have anywhere from 5 days to 30 days to sometimes even longer in order to respond to this request. The officer in such kind of situations would highlight what exactly is their concern, under which section of the law they are identifying this concern, and where it impacts the section of the law, and what you must provide to allay the concerns of the officer. Whenever you receive, or if you receive a PFL, please take it extremely seriously, because any wrong move here and you not being able to satisfy the officer's concerns would result in your application being refused. And more so, it could also in some cases lead to misrepresentation and 5-year ban along with it. Of course, I will show you some examples of different kinds of PFLs that I have from the most recent period, so that gives you an idea of what PFL looks like, what you should be looking out for, what you can do. Now, a lot of applications get actually rejected in the R10 stage. R10 is under the Immigration Refugee Protection Regulation, Section 10. This is the section which states that you must provide a complete application. So if you do not provide a complete application, then the officer is not obligated to ask you for additional document requests or send you a PFL. So for example, if you don't provide a proper birth certificate for your dependent children, you don't provide a marriage certificate in a proper format from the authorized government agencies, you do not provide a police clearance that is required in your application, all of these will warrant that your application be rejected right away at R10 stage, without the officer asking you for additional documents. Now, when it comes to the additional document request section, then as I explained to you earlier, the officer can ask you for additional documents supplementing the information, the documents that you have already provided. Just additional support, additional proof, or even updated proof documents for that section, that is called the additional document request. And then, as I explained, the PFL. So let's get into some PFLs to understand how and where they can impact you. As you would appreciate, a lot of this has been redacted. I've put X marks over there. These are all original PFLs from recent times, and I've put these X's obviously to protect the identity of the individuals whose PFLs these are. The first one is for an individual who received it at the P2 stage. And here it is being said that I am cancelling your COPR. It has been cancelled as the address that you have provided does not match the province of destination. So this is for those individuals who have got a provincial nomination, and when they have got their P2, they have uploaded their address which does not match with the province of their intended nomination. So obviously this individual is inside Canada, the person is living in a different province, they have a nomination from different province, and rightly so, IRCC is questioning that if you are in Canada, why are you already not living in the province which is nominating you, and what is the reason here? And this is the discrepancy. Obviously a very serious matter, and as I said, it can happen at any stage, and this is happening at P1, P2 stage where the applicant has uploaded their address details. So a very, very serious one, and if you don't respond it in the given time, then you get a refusal right at the very end. As you can see, even the confirmation of permanent residence, the tracker, the number that you see in the tracker, even that has been cancelled. The next one also here is with regards to your intention of settling in the province. Again, a provincial nomination, not at a P1, P2 stage, much earlier, but this was for a person who was living in a different province other than the province who had nominated, in this case, Ontario. And IRCC is asking, well, hey, we asked you for an additional document request. We asked you to complete Schedule A, the IMM 5669 form. You have completed your studies. You have lived and worked in the province of Quebec, which basically means you have not yet moved to Ontario, and why are you not moving there? And therefore, you need to explain why is it that you are not moving to Ontario, and it seems that you don't have any ties there. So definitely a concern, because as you know, in express entry, you are expected to provide your intention to reside outside Quebec. And in this case, you have a nomination from a different province. You are still continuing to reside in Quebec. Therefore, a big, huge concern for the officer, therefore triggering a PFL. This is another instant case, interesting one actually. This one was a situation where a person has claimed Canadian work experience, but the officer has concerns about the genuineness of the work experience. Now you see, this is where the officers are going deep diving into your work experience. They're trying to identify what you have done, where you have done, what kind of work experience you have. Is it matching with the knock code? No, it is not matching with the knock code. That's what the officer says. Further, the officer is identifying that you have work experience. Your past education is in dental surgery. You have been working in healthcare field, and it says in your previously declared foreign and Canadian work experience, the occupations that are included are dental interns, customer sales representatives, retail store supervisor, and absolutely there is no documentation or anything to show that you are now working as, over here it says under 22233 construction inspector. So a genuine concern that the officer had, and therefore they have this concern that your work experience does not corroborate, and therefore the concern from the officer triggering a PFL. Another case of work experience, this is where officers become very, very serious, and it says, in your express entry profile, earlier profile, which you didn't even submit, okay? This was the update. You declared your employment with company X. Then you made another express entry profile, and there you declared your experience with company Y. And then you have updated the information, and you have declared employment as a production general manager in a different company altogether under a different knock code. Now, this is where you need to understand. When you make those changes in your express entry profile, they are always recorded. They are always creating an electronic footprint. If you ever think that you can create an express entry profile and nobody is ever going to question because, hey, you did not submit it. No, every time you are pressing on that keyboard, every time you're clicking on that keyboard, it is always recording all the information. And once you create your express entry profile, you cannot delete it. You can withdraw it, but you cannot delete it. That information is there forever, recorded there. Of course, IRCC keeps it for 2 years, but they can still go back to that information. Here is a classic case where a person has made changes to their express entry profile, withdrew the profile, recreated another profile with different information, and got caught with this one. And this one again was a very, very serious one, obviously indicated misrepresentation here as well. And yeah, a pretty serious one. And of course, they're asking for this whole situation, like what exactly is going on here? There you go. This is another one with employment. You see how investigative, or rather how investigative these officers can turn into, because they really want to find out what exactly is going on. Here it says, on the 17th of February, whatever date is, you declared employment with this company as a doctor, and then you updated your declared employment as a general practitioner, and then in your current application, your declared employment is with a different employer from different dates. There are too many discrepancies, and please provide documentation to address these inconsistencies. Again, you see, when you're creating your express entry profile, you're indicating different dates, and then you go back and you change those dates, and then you create your application, and then you change those dates again for whatever the reason might be, whatever you're trying to do in there when you make those changes. Because hey, if you're working with company A from X period of time to Y period of time, that necessarily doesn't have to change, right? Right. But this is what happens when people make these profiles. They forget that everything is recorded, and if they are making any changes, they must provide an explanation upfront. Otherwise, it triggers a procedural fairness letter, as I am showing you. Moving on to the next one. This one is inadmissibility for misrepresentation. This is very interesting. This is what I've been telling you guys for such a long time, that if you have not disclosed work experience in the past in your previous applications, study permit or work permits, and if you now choose to show it in your express entry applications, bam, you can get caught, and then you will have misrepresentation. Here, it says, following a review of your application, it is noted that you have provided contradictory information related to your employment history. On your application for a work permit, you listed employment with some company, and then in your express entry application, you listed employment with a different company. There is no mention of your employment with the company that you have given, nor is your employment. Again, there is a lot of redacted information, and I'm sorry, I obviously cannot disclose all the real scenarios over here to protect the identity of the individuals, here, so you can appreciate that, right? And again, the point is to get to the crux of the matter. The point is to see where things are becoming serious. And again, in this case, a subsequent application for express entry that was submitted also does not include your employment. So profile was submitted, withdrawn, application was submitted and then withdrawn, and new application was submitted. Everything is being taken care of. Everything is being looked at. And here it says the misrepresentation or withholding of these material facts induced or could have induced errors in the administration of the act. And therefore, this person actually did get slapped with misrepresentation. Eventually, this is now being taken into the federal court under the judicial review. Obviously, the application was refused because this person just could not explain why there was this huge inconsistencies. And then final one that I have for you is, as you can see in red, specifically, I have concerns that you did not disclose your previous US refusals and enforcement. And this is with regards to flag polling. You know, when you go for flag polling or for a postgraduate work permit, spouse open work permits, or whatever work permit that you've done in the past, you've gone to the US side, you've taken a U-turn, you've come back. On the US side, you have been denied entry. Yes, it was administrative refusal, I agree, but it was a refusal nonetheless. And therefore, in your application, express entry application, PR application, study permit applications, visit visa application, no matter which application it is, you must mention all refusals, denied entries, whether it's to US, whether it's to Canada, whether it's to any other country, it must be included. It must be included in the statutory questions. If you don't, it triggers a PFL. It can also, you see, as it says over here, highlighting this as misrepresentation, which will then bring you a ban of 5 years. So they're telling you that you have done this is considered misrepresentation. If you do not give us proper explanation as to why you did this and what happened, we would consider this as you having misrepresented, bringing on a 5-year ban. This is just few examples. Now, we deal with so many such cases that I can't even explain to you. People really, listen, express entry application is a simple, straightforward application. You know it, I know it, it's not a big deal, it's not rocket science. There are tons and tons of DIY platforms, forums, Facebook groups, YouTube videos that can help you handle your own application. But you have to be aware, you have to be smart, you should know what you're trying to do. This is law that you're dealing with. This is very, very serious stuff that you're dealing with. So when you make these changes, when you think you're too smart, when you think you're trying to fool the system, hey, who's going to find out? If I make a few changes, nobody's going to know about it. I will withdraw my profile, I will make a new profile. IRCC won't care about it because I'm not submitting it. Everything is recorded, everything is known. Your previous applications, your previous visit visa applications, TRV applications, study permit applications, work permit applications, spouse open work permit applications, previous express entry profile, previous express entry application. Everything is available to IRCC to validate, to check, because integrity of the immigration systems is now being checked, rather is being verified. That has basically the priorities up there, high there. I really like it. There is another case for which I cannot show you the PFL because there is so much of details in it that redacting it or cutting it out was just not possible. But that is a case where IRCC has triggered a PFL for somebody's work experience because they have gone to the extent of checking the person's supervisor or manager. They've gone to the LinkedIn profiles, they've checked the location of that office, they have checked where the office is registered, they have checked the company's registration, where the company is registered, they have checked the employer's details, the person who has signed the documents. They have seen so many variations, they've seen so many inconsistencies, and therefore it is like a 4-page PFL asking for so many different things. We deal with these PFLs all the time, basically, and a lot lately. except for all the PFL that I showed you, except for one, which basically was refused because there was no way to get out of it. I mean, the person had blatantly lied in that application. And as much as we tried to counsel the client and tell them that, this is not going to help you at all from what you have done, that is, as I said, at this point of time being is in the federal court for a judicial review, because the client obviously then chose to go to an immigration lawyer so that they could go for a judicial review. But in all the other cases that I showed you, thankfully, we were able to overcome the situation. All of them are in the final stages or have already got their COPRs and already got their approvals. But when you get these PFLs, don't take it lightly. Don't just write a two-line explanation saying, hey, you know what, this is what happened. I went for a flag polling and I forgot about it. Just don't leave it at that. Provide a detailed explanation. And whenever you get a PFL, it would have detailed concerns. It is your responsibility to highlight every single concern, address every single concern, provide detailed information, explanation, evidence, supporting the documents to ensure that the officer is absolutely satisfied with your claims, with your documentation, with your work experience, and everything corroborates. This is extremely important. This is what I wanted to show you about the procedural fairness letters, so that when you submit your application, you can make sure that you don't get one at all. We don't want to see this happening. But if you do get one, well, then give us a tinkle. Let us know. Hope maybe we can help you. And for that matter, if you think you cannot handle the PFL, consult with an immigration lawyer, immigration consultant, immigration practitioner, somebody who knows what they're doing, so that they can help you get out of that pickle. I hope I was able to give you some more clarity on these matters. Like, share, subscribe, and of course, come back again for another video once we do that. Stay forever hopeful, and I'll see you next time.